Good evening. Thank you for joining this evening for our discussion on SLAPPs, co-hosted by the Foreign Policy Centre and Prospect Magazine. My name is Rupert Cooper-Coles, and I'm a partner at RPC, which is one of a few media litigation firms that represents media organisations and journalists in this jurisdiction. In that capacity, I'm on the Law Society's working group on SLAPPs and gave evidence to the House of Commons Select Committee, Justice Committee on this issue last year. I'm going to speak for just a couple minutes before tonight gets underway. Tonight's speakers are, I expect, well known to most of you here. Carol is one of the most respected and well-known journalists working in Britain today. She's one of the few British journalists to be a household name on account of her investigative journalism, and in particular, her reporting on the Cambridge Analytica scandal. Her journalism has had a lasting impact on some of the most important political issues of recent times, including the role of technology in democracies, Russian political interference, and more recently, the issue of SLAPPs. Gavin is one of the most capable media silks at the English bar. He's acted on many of the most important media cases of the last 20 years, including Jamil and Dow Jones, which is probably our best common law authority for dealing with SLAPPs at the moment. He's well known for being a strong advocate of free speech rights in and out of court. Alan is the editor of Prospect Magazine, and of course, was the editor of The Guardian for over 20 years. Before becoming editor, he was himself a reporter and columnist. I can't think of a better person to lead this discussion. Most of you will have an idea of what a SLAPP is. The acronym stands for Strategic Litigation Against Public Participation and describes media litigation, which seeks to stop public interest journalism in a manner that is abusive, usually by placing inordinate financial pressure on a publisher. I'm interested to hear where the discussion leads us tonight, but here are a few observations which I think are worth sharing, derived from RPC's experience at the coalface of media litigation. We have one of the most complex and expensive legal systems for resolving media disputes in the world. It usually costs over £1 million to defend a defamation claim to trial on the basis of either truth or public interest. Under our legal system, a successful party can generally recover their legal costs from an unsuccessful party. So if you lose at trial, you're generally looking at a total outlay of over £2 million. Legal costs are usually the central issue in every media claim. The cost risk drives decisions to settle claims, apologize, and withdraw public interest journalism. Often these decisions are taken for purely commercial reasons with little regard for available evidence or merits. It only takes communication to one person to enable a claimant to bring one of these claims. So a single tweet or sentence in a long report can result in this sort of cost exposure. Striking out abusive litigation through existing common law precedent is risky and expensive. If an application to strike out fails, the defendant may be ordered to pay hundreds of thousands of pounds to the claimant in any event and still face the prospect of raising £1 million to defend the claim to trial. If the strikeout is successful, it still may be difficult to recover costs. This underscores why existing measures are not effective or sufficient. The context above is taken into account in editorial decisions about whether and what to publish. When it comes to reporting serious allegations about the wealthy, the risk of being dragged into ruinously expensive litigation is substantial. So much of the chilling effect of SLAPPs on public debate is actually unseen and very hard to measure. On a more positive note, improving our legal regime should be possible. Some 36 states in the US, Canada, and Australia have statutory anti-SLAPP laws, and the EU is currently considering a draft directive. Under other UK areas of law, namely intellectual property law, have mechanisms for both controlling costs, the IPEC court, and compensating defendants who are subjected to unwarranted legal threats. Happily, there does seem to be wide cross-party support for change. Following a consultation last year, the government has committed to bringing in statutory changes to give judges powers to deal with SLAPPs through an early dismissal mechanism, which would place a higher focus on the public interest. The UK Anti-SLAPP Coalition published a model UK Anti-SLAPP Law last November, seeking to articulate a legal framework which would advance robust protections, building upon the framework outlined by the Minister of Justice. This model law has already received widespread support from journalists, editors, NGOs, academics, and politicians from across the political spectrum. None of this is to underestimate the challenge of getting statutory or regulatory protection against SLAPPs right. The right to a fair trial and to respect for reputation are human rights, which any law will need to carefully balance. SLAPPs are not always easy to identify. Controlling costs in complex litigation is an enormous challenge. Lawyers are misled by their clients and can only do so much to check their instructions. Solicitors and barristers have a duty to act in their clients' best interests, and only in exceptional circumstances may come off the record. Legal professional privilege makes scrutinizing unethical conduct difficult. All of this, I think, explains why this evening's discussion is both important and set to be fascinating. So with that, I'll hand over to Alan.
Thank you, Rupert, and thank you for coming in. I can see a lot of very distinguished figures in the audience. I'm hoping there'll be a lot of questions, and I know there are other people watching online, and we're going to be monitoring any questions that you want to put in. So we'll leave time for that at the end. But meanwhile, we've got two people I admire greatly and have even had cause to consult occasionally, Carol and the person who represented her in her legal travails, Gavin. Carol, do you want to begin? I said before we sat here, I'm sure you've told the story and you claim not to have told it endless times, but really you were subjected to two different bouts of threat. One over your Cambridge Analytica stories and one over the Arron Banks affair. Do you want to just describe what it's like to be at the heart of that kind of legal barrage against you? One, I mean, it's with a newspaper behind you, one very much on your own.
It's interesting, isn't it? Because we were just talking earlier and Gavin mentioned, because I also consulted him back in 2017, I think, which was when we got the first barrage of legal complaints against The Guardian, against me personally, for our reporting on Cambridge Analytica. And it was enormously stressful. And Jill Phillips is in the audience here. You know, it was a massive task for the newspaper to respond to that. And it was very, very scary because at the time, you know, we knew the company was owned by a billionaire who was ideologically motivated, who'd supported Trump. And we'd just seen actually the example of Gawker Media in the US being shut down. So it was very real. There was real questions about whether we'd be able to carry on reporting. I think that was when we sort of partnered up with the New York Times. That became a sort of important help in that. But I mean, it was also completely different in that, because it was although it was directed against me personally as well, it was directed against The Guardian. And so it was dealt with by the in-house legal team. And although it was enormously difficult, and that question about, you know, being desperate to sort of continue to publish, it wasn't the same sort of existential threat of having litigation against me personally, which is the difference with the Banks case.
We'll come on to that. Just pause there. And I mean, obviously, in the Cambridge Analytica story, you won. You got the story out, and it had immense repercussions. Was there a time when you were inhibited or prevented from writing stuff that you wanted to write because of the threats that were coming in?
I mean, absolutely. I mean, I think through the whole of 2000, I mean, we got the first threat in sort of the spring of 2017, and it escalated. And then in the autumn of 2017, I think it was a sort of 50-page pre-action letter. And it was a huge task for the legal team to respond to that. And Jill made it very clear that we weren't publishing another word until, you know, we responded to this in this really full way. But, you know, we also thought that they could actually what's the terminology? Actually serve proceedings. Is that right? Issue proceedings at any point. And if they had, then we would have been stopped in publishing.
For a period, they succeeded in silencing you.
Yeah, and it was just this constant jeopardy of whether we were going to get the story out before they issued proceedings. So, and as I said, this was when the partnership with the New York Times and with Channel 4, to a lesser extent, were very important, because we had the 3 news organisations, and I think that kind of gave comfort and sort of legal support.
So that was one action, and then you gave a TED talk and you tweeted.
I mean, there was a few others in between as well, but yes, but then so subsequently, let me think about it. I mean, there have been. I mean, the whole thing is that anybody who is a journalist who works in media law knows that any kind of reporting brings in the pre-action letters and the legal threats and warnings. So, across this period, there were a lot of people. We got a lot of letters about other things, privacy actions, other threats which didn't go anywhere. So, and banks had always been sort of writing letters. He'd been making legal threats on Twitter. He'd been threatening me with in other ways on Twitter. There'd always been a level of threat from him, but we had published the thing which there'd been a sort of body of reporting into him which had actually launched certain, with our reporting and that of Open Democracies primarily, there were legal investigations which were initiated into banks as a result of this reporting. But the thing, and he sort of accepted that, but the thing which, he really reacted to was our reporting about his relationship with the Russian ambassador and the negotiation of deals with a Russian businessman inside the Russian embassy in the months before the Brexit vote. And that was the thing which precipitated a whole new area of threat, including his first reaction for that on the reporting of that was to report me to the police. And he accused me of computer misuse. He accused me of hacking these emails, and he accused me of threatening and blackmailing somebody.
We're slightly compressing this story for reasons.
Yeah, sorry.
But the point was that you, as an individual, were now faced with a very, very rich man who was suing you personally. You didn't have the Guardian behind you by now because this was unrelated to stuff that was writing the Guardian. What did that feel like?
So apologies, I'm not telling this very well. I think it's, as I said, I actually haven't sort of told the story in its entirety at any point, really. But so we wrote the stories about banks and this relationship in the Observer in the summer of 2018. Almost a year later, I went to TED and I gave a talk, and I referred to that reporting in the same words that I'd used in the newspaper. And it was at that point, actually, it was at that point that he, there's a tiny little extra detail, which was, that wasn't quite the moment that he took legal action. The moment that he took legal action was when I tweeted the trailer to a Netflix documentary which was coming out, in which I appeared. And I rather foolishly, in hindsight, said, something about, I think you'll find this interesting, Aaron, or something. And it was at that point that he sent me a legal letter. And he also he sent Netflix a legal letter. He sent the producers a legal letter. And he had to withdraw those because he wasn't actually in the documentary. I had just sort of trolled him.
If we get to the peak of that action, I know you were crowdsourcing your action. How much money was in jeopardy for you? I mean, what were you on the hook for?
Well, it's just as Rupert said, it seems to cost about £1 million to go to trial, and if you try and fight it, you're just at any point you're going to be faced with the legal costs of it. It's not the damages. The damages are sort of almost inconsequential in comparison. It is the legal costs. And so it's the threat of adverse costs, which is the main jeopardy. But it's not just, I think one of the things I've always found about the case is that it's the money is the thing that people can understand, and being on the hook for £1 million, well, I mean, how on earth are you going to pay that? But actually with SLAPPs, it's the sort of, as I say, the existential threat of it is far even bigger than that financial threat, because it's about your reputation, which is your career, it's your livelihood, as well as your financial security. And in my case, it was being exposed to this cauldron of sort of online hate, not just online, but also from the right-wing press in the UK, in the US, the Russian-funded one. It was constantly being put through the spin dryer of that, and knowing that if I went forward and lost this, that it would have just been open season, and it would have been very hard to pick myself up afterwards from that. So that's the thing where I sort of say it's that I think it is different from other civil suits in that way. It didn't feel that this was just a legal case and there was money at stake. It was very much more that it felt like my sort of life was on the line throughout it.
So to compress a very long story, and Gavin, you'll correct me, in the end, you won on about 2/3 of the case, but you've had to pay him a small amount. Well, not a small amount, a substantial amount. I mean, £35,000 or something.
So what Gavin was able to brilliantly show in the case, and he'll obviously do this much more fluently and effectively than me, is that the talk was lawful at the time that I gave it, and it was lawful because this was absolutely in the public interest. And that has been proved, and that stands. And the entire judgment, which goes in detail about Banks's relationship with the Russian ambassador and Russian interests, and all the many times that he was having those meetings before Brexit, that is all there as fact, now assessed by the judge. What changed in the appeal was that he won on this one point, which is that after a change of circumstances, that the public interest defence no longer held. And the change of circumstances became a year later when Gavin's probably going to correct me on all this now, it came a year later when the National Crime Agency dropped its investigation into the source of his Brexit funds. So, and at that point, the court said that 100,000 people in the UK saw the talk after that point. And so that's what I've been held liable for. And that's why I've had to pay the damages. Obviously, I don't publish or control the talk. It's on a website of an American publisher published out of America. I'm not the editor of that, but I have been found liable, and that's why I have to pay that bit.
Gavin, coming to you, one of the judges, since this is the thing we're talking about tonight, one of the judges who heard this case, Mrs. Justice Stain, said as follows: Ms. Cadwallader has repeatedly labelled this claim a SLAPP suit. Although for reasons I have given, Mr. Banks's claim has failed. In my judgment, in circumstances where Ms. Cadwallader has no defence of truth and her defence of public interest has succeeded only in part, it is neither fair nor apt to describe this as a SLAPP suit. So there's the judge saying, this isn't a SLAPP. I wonder what you make of that.
Well, with SLAPPs, in the definition of SLAPPs, you pay your money, you take your choice. There's no legal definition of a SLAPP in this country. Different people have different views about what a SLAPP is. Because we don't have a legal definition of SLAPP or an anti-SLAPP law, we didn't argue in the case that it was a SLAPP. The judge expressed a view on that based on her own articulated understanding of what might be a SLAPP, what might constitute a SLAPP. And that's fair enough, that's her view of it. But it's not really the main point. The main point is why don't we have an anti-SLAPP law? And what would the anti-SLAPP law say a SLAPP was? And how would it deal with a SLAPP?
So just pause there. So then that's the heart of the evening. But do you agree that it's difficult to pin down exactly what a SLAPP is before you can even start thinking about what an anti-SLAPP law might look like? Or do you think it's a relatively simple question?
No, it's a very difficult question. People, as I say, have different views. My own view is that the heart of a SLAPP, or the definition of a SLAPP, is a very intense focus on what the societal value of the speech or the activity in issue is. So the postulate is the defendant has been engaging in an activity or speaking in an area where there is a public interest, a debate of societal importance. And courts regularly ascribe value to that sort of speech or activity, higher or lower. How important is it in a democracy, or unimportant is it in a democracy? The starting point in identifying a SLAPP is to look at the speech or the activity concerned, value it, and decide whether it has sufficient importance in a democracy to have an extra layer of protection around it. This is what we're arguing about with an anti-SLAPP law. Building procedural protection for people who are threatened with that sort of suit in that situation, or actually sued, that enables them to get rid of the case early, or if they can't get rid of the case early, to get cost protection or other forms of procedural protection against these consequences that Carol describes, you know, the long slog, vast costs, stress. The big issue is how you frame that procedural protection that you put on top of the substantive law, on top of our speech law. Personally, I think the big problem we have in this country is compared with America, where they have First Amendment laws, is that the starting point for the protection you're building is the underlying law, it's the substantive law. How does your defamation law work? How does your privacy law work? How does your intellectual property law work? Is it itself sufficiently protective of freedom of speech? And of course, in America, it is strongly protective of freedom of speech. Here, in my view, it's not sufficiently protective of freedom of speech. So that's why you need an anti-SLAPP law, but it also makes it quite difficult to build the protection on top of that, because the underlying law isn't strongly enough, isn't designed to protect freedom of speech strongly enough.
The Ministry of Justice has been trying to craft some form of anti-SLAPP protection. But I think in your view, and you wrote about this in Prospect a few months ago, it doesn't cut it for you in terms of what it's trying to do.
No, it doesn't. I mean, it would be better than nothing if they were to do it. It was on the horizon. The horizon is moving further and further into the distance, as far as I can see. I don't know if there's going to be legislation or when we might have it. But the proposal was essentially for defamation law, though for other law as well, that you would have a three-part definition of a SLAPP. You would look at the speech. Is it public interest speech? Yes, fine. You would look at whether the circumstances surrounding the litigation have what the Ministry of Justice called the hallmarks of a SLAPP, some of which Carol has described, you know, the threatening letters, the 50-page argumentative letters, the threat of costs, so on and so forth. Do you have those hallmarks? Yes, second criterion. And then thirdly, what are the merits of the case, which is the $64 million question from the point of view of the claimant. So that was the structure of it. And then they said, well, you know, you can, if you establish a SLAPP, the court can look at the merits and decide whether to throw the case out early. And if it doesn't do that, it can give other protections to the speaker, costs, and so on and so forth. All of which would be fine on one view, but doesn't go far enough as far as I'm concerned, because the test that was proposed for stopping, it's all very technical, the test that was proposed for stopping the case is whether it was a case with a reasonable prospect of success, and if it had a reasonable prospect of success, it could go on. So it was in effect what we call a summary judgment test, summary judgment application. And from my perspective, that's not strong enough protection. I mean, we've got that already. So it was fudge, it was a cop-out. And the stronger protection that you need is a much broader balancing of the societal implications of allowing the case to go ahead. What does it mean for the speaker? What does it mean for the defendant? What does it mean for speech around that topic in general? Is it going to inhibit that? You need to balance that against the harm to the claimant caused by the particular speech that's been sued on. Is it a big deal? Is it terribly damaging to their reputation? Are they very vulnerable? Or are they a big corporation? Are they a wealthy individual who can use PR firms to spin their contrary case and so on and so forth? That sort of balancing by a judge is not something that really happens in this country, but tends to happen more in America under the First Amendment. But I think it should happen here, and I think we should learn to do it here. So it's a very long answer.
No, that's really helpful in terms of framing it in a legal way. I'm interested, Carol, in what we might call the court of public opinion, because Gavin's talking about the way that the law of defamation has changed actually quite positively in recent years. You know, when we were doing a lot of heavy lifting on The Guardian in 10, 15 years ago, the idea of being able to appeal to the public on grounds of public interest was not so readily available. So that's a positive development. But this, the idea, the notion of SLAPPs, which has been, as you say, around in American, European countries, is a reasonably new one in public discussion, and that's really because of the Russians. And Putin, yeah. and people trying to stop books like Catherine Belter and Oliver Bullough. Can you just talk about?
Yeah, but that's right. I mean, and it was, you know, the timing of those cases against Catherine and Belter and against Tom Burgess was so striking at the moment when Russia invaded Ukraine. And I think it really just did turn around public perception of understanding the ways that these laws are being weaponized to chill reporting into people we now know were enabling, you know, Putin's genocide or bloodshed. I mean, it was a very stark moment, and thank goodness that people could see that. In my case, it was more complex, because it's always been more complex, because reporting on anything to do with Brexit is such a contested space in this country. And so it was always been my reporting was perceived as partisan, when it was simply investigative reporting, but it was reported out by other outlets in a very partisan way. And I became as I call it, a kind of culture war hate figure in that, because I was seen as perceived as sort of trying to overturn Brexit. I think just back to the issue about the SLAPP aspects of my case, which is that there was the words in the judgment where the judge said, this is not a SLAPP. And as Gavin has said, of course, there's no definition of that. So it's kind of meaningless. But also I think this whole thing about, we didn't put that evidence into the case, but you didn't put any of that evidence before the judge, because that couldn't be part of the case. All I was doing was defending myself. I couldn't actually put forward and as I said, there's a body of evidence, which was not just his legal behavior, it was also these threats, a pattern of behavior over 7 years, which went way beyond the legal and had, you know, gone over sort of many years. And I think understanding the behavior also outside the legal context is, you know, in my view, is part of what makes my case a SLAPP. The freedom of expression organisations say my case is a SLAPP. And most particularly, he did not sue The Guardian or TED. And that was the coming after me as an individual is the thing which for me is the sort of key aspect of it. and holding me liable for something published by
Yeah.
another organisation.
Yeah.
This is one of the central issues about SLAPPs. If you adopt the more conventional approach, not the one I've just advocated, but the one which has the court looking at the purpose or the intention of the claimant, deciding whether it's in some way abusive, the law recognises, because then you open up an area of evidence that we don't get in the libel case itself or in the substantive proceedings, which I always like to think of as the what's going on here evidence. You know, what's the history of this? What's the prehistory? What's the animus of this person towards the defendant? What's really at stake for them? What's to gain? What's to be lost? Why are they putting this amount of resources into doing this? Why are they doing it in this way, using these lawyers, making these threats? There'd be a whole area of evidence about that you get before the court at an early stage in the proceedings, and the court would have to start taking decisions about whether, on that view of what a SLAPP is and how you stop one, that's sufficiently concerning or worrying from a free speech point of view to stop the case early on. Those are not things we do in this country. They're not things judges do here. And my question rhetorically is, why not? You know, why not, if free speech in the public interest and the societal interest is important? Why shouldn't judges look at those things and have the power to stop a case early on and prevent all these sorts of consequences if the evidence about that is strong enough and concerning about that?
It's become quite a political hot potato. Whether it still will be with the new Justice Secretary, we don't know yet. But a lot of legal firms were put in the dock after the invasion of Putin, and people were exposing all these legal firms around London who were making a lot of money from Russians and Kazakhstanis and blah, blah, blah.
And facilitated the suppression of journalism into these individuals. I mean,
sure.
But
I just want to make a different point, which is reading the legal press around this. There's obviously a number of legal firms who feel rather persecuted by this interest in what they're doing. And I'm just going to read a bit from the managing partner of Brett Wilson, a man called Ian Wilson, in the Law Society Gazette last month, who said as follows: the campaign against SLAPPs is essentially just another attack on the law of defamation. The invasion of Ukraine and sanctions on the oligarchs gave the media the perfect platform to rally public support. But at the end of the day, lawyers are just facilitators and go-betweens. The perception that defamation lawyers help the wealthy suppress public debate is one I find particularly offensive. There are very few cases where the claimant is the wealthier party. Normally, it's the defendant that has the upper hand financially. To be clear, where they do exist, SLAPPs are a problem, but their prevalence is overstated, and solicitors are unlikely to be complicit in very many. Do you have any sympathy for that?
No, the truth is, we all know there are both types of cases. There are cases where the imbalance is in favour of the claimant, and there are cases where it's the other way around, where an individual who isn't wealthy or powerful has to end up suing a large media corporation. I don't think any of us should pretend that's not the case, but that's not the issue. And I don't think any of us should get drawn into an argument about obligations of lawyers, you know, beyond a certain point, because the primary obligation of lawyers is to represent their clients and represent their best interests fearlessly and in good faith. That's not what we're about here. What we're about here is the use of the law and the threat of suit as an instrument to suppress societally important activity and speech, and whether the state, whether our democracy gives judges the tools in the most worrying and concerning cases to do something about that effectively early on against powerful people, to prevent the chilling effect that Carol speaks about. And that's the bottom line with SLAPPs. I mean, you very few, and anti-SLAPP legislation, very few cases get to court. Any defamation lawyer, any media lawyer will tell you, most, you know, just tiny percentages can get to court. There is a continuum in a free speech case, from the first threat through to the end of a case. And cases fall largely at the initial stage. The threat has an effect, has a consequence. And Stories are spiked, people's names are taken out of stories, allegations aren't made, even though would be in the public interest to do that, for fear of these consequences that Karen has described. The value of an anti-SLAPP law is not actually going to be mainly in its application, because a few cases get to trial and would get to that point. The value of it would be that potential claimants know that it's there, and potential defendants know that it's there. And they will be emboldened to take the case and fight the case in the knowledge that it's not going to bankrupt them, and it's not going to destroy their lives, and it's not going to take all these years out of their lives. If their lawyers say, you've got a SLAPP case here, you've got an anti-SLAPP application here. So the question is, why don't we have that law?
And I mean, and I think, Gavin, you said to me, I think last year, that you'd been looking at the body of reporting and investigation into Arron Banks by multiple outlets. If there was, you sort of said there was this much in the, but there's articles and articles. It stopped completely dead with this lawsuit. It absolutely chilled all reporting. And I have to say that I felt, it's a strategic litigation against public participation. It definitely has had an impact on my public participation. And in that sense, I would also say that it's worked.
See, none of this is new. That we used to have the gagging writ. You remember that? You were an old timer. You're an old timer. You were an editor and a journalist.
That's the old timer stuff, if you don't.
Yeah, at common law, it was called the gagging writ. We had the gagging writ. Somebody issued it, and all speech against that person or on that subject stopped. What's changed is we now call it a SLAPP, and we now have impetus, political impetus and societal impetus to do something about it. It may just be a spike. It may be a temporary phenomenon. It may come to nothing. But we've got language to describe it that's a little more sophisticated than gagging writs. So we've got this concept of a SLAPP, and we're able to adopt and talk about the American concept of a SLAPP.
If we've got a microphone, I'd love to hand the microphone to David Davis, who's in the front there, because I'd just like to sense David's sense of what the political appetite, whether the political appetite is still there, and what kind of coalition there is.
Okay, well, first a factual thing. The big debate in the Commons started actually the month before the Ukraine debate and the Ukraine invasion. What changed, of course, was the public interest in the argument. I mean, on the next day, I think we had one small piece in the eye or something, and that was it. So that's the first thing. I mean, and to some extent, of course, what goes on in Europe is feeding this, but Russian oligarchs aren't the only players in this. Second thing to say is today we had the new Justice Secretary's first outing in the Commons, and he was asked about SLAPPs, and he sounded very sympathetic to the arguments. I think somebody's seen him already. I'm not sure who, but somebody's seen him already to talk about it. So I think the appetite is still there. The third point, I think, is he was worried, if I read him right, that we don't get it wrong, that we don't somehow suppress defamation law altogether. I mean, to put it in its strongest. And can I finish with a question?
Sure.
And to say to Gavin, I'm very much sympathetic with Gavin's view on this, but could we write effectively the First Amendment into British law? Is it possible? And if so, should we do it?
Well, that was something that they've fought shy of doing in the consultation document and the response from the Ministry of Justice. It's a big issue. We don't have a serviceable, across the board, general public interest speech or public interest activity right in this country. It's a quasi-constitutional right, which can be brought out and used in argument in all cases. We have particular pieces of law that give a role for public interest speech, enable it to frame arguments in that area of law about that. In others, we don't. There's this old issue that's come up again recently about official secrets and the National Security Bill, that there isn't a general right of public interest speech which would protect journalists or NGOs.
But for
against
us non-lawyers,
sort of action.
Gavin, can you explain why Article 10 of the Convention is weaker than the First Amendment?
It's not a constitutional right. It's not a general. You can argue in any case in this country that results in an interference with your free speech rights that the substantive law in that case should not be applied in a way which results in a violation of your free speech right. It's not as strong a right as the First Amendment right. It doesn't give as much protection to free speech. And it's not universally available across all areas of the law as a constitutional right. And that makes a big difference for lawyers arguing the defence case.
So should the question really be asked to David, that what's stopping your government producing a First Amendment style protection?
Right.
Well, I think it's not just my government, it's any government, frankly, in this country. I think the state is antagonistic to the idea of a particular journalistic privilege. You will remember the Edward Snowden episode where you ran right into that problem. And you're right, it's so, as it were, a sort of facsimile of the First Amendment rights. For Britain, I think it would be a very good argument to have. And even if we didn't win it, it would mean we'd come out with the outcome would be better than what we're currently aiming at, which frankly, I agree with you, is a bit soft and woolly.
And the big problem with it is that you're building in these procedural protections on top of a body of law, a constitutional law that doesn't have that right in it.
Mm.
So when they built it in America, it's much more valuable as a protection for free speech because the lawyers who are running the anti-SLAPP arguments can point to the First Amendment. Here, we're not really in a position to do that in the same way. We don't.
It's a great mystery why the Labour Party won't support the introduction of a public interest defence into the National Security Bill.
Yeah.
Because there's willingness on both Conservatives and Liberals. But anyway, that's a slightly different point. How are we doing on? Have we got? All right, we've got a question online. Then I'm going to turn to the audience here and see, because we've got so many interesting people here. I know there'll be interesting questions. Yes.
I'm going to adapt it slightly,
All right.
but speaking to Carol's point earlier about how widespread SLAPPs are, could you talk a bit more about why we don't see them in the press, the ones that get to the trial stage? And also the person is wondering how significant the issue is beyond journalism in England and Wales.
Beyond
journalism and journalists.
Because your point is that actually it's not just journalists. There are. I think you made the point that the trespass laws and environmental and animal rights campaigners are also subject to SLAPP.
It's NGOs and protesters, yeah. and it was noticeable in the Ministry of Justice's consultation. They mentioned various types of claim that might give rise to SLAPP arguments. The one they didn't mention was cases brought against protesters. Yeah.
Carol.
There's an interesting one as well, which I actually made a point of telling David Davis about, which was that this wasn't Aaron Banks's first rodeo. He actually took a defamation proceedings, not against a journalist, but against a public body, against the Electoral Commission. And it's a really interesting case because the point at which the National Crime Agency dropped its investigation into the sources of the money that paid for Brexit, the Electoral Commission put out a statement, and that they said that we think that this creates a loophole by which foreign entities can fund British elections. And they put out a kind of statement. It was quoted in the press, and Banks took legal proceedings against them, and they had to withdraw that statement and erase the page from the websites, and that is now struck from the public record, and as is reflected in my judgment. And, you know, the case about that I find really deeply worrying, because a publicly funded body, there's no way that they can go and spend a couple of million to defend a defamation claim. And nobody knows about that case. That, you know, I mean, even I didn't really notice it or understand what was going on at the time. And so I think, how many times is that going on up and down the country and in local authorities as well? I mean, I think one of the things about this in journalism is we hear about Catherine Belton, we heard about me, we heard about Tom Burgess, but there are journalists in local papers up and down the country who are getting letters, not knowing what to do. These papers can't possibly afford to defend them. And I find that even more worrying, I have to say.
Gavin, what do you advise your clients when they get legal letters that are marked private and confidential? Because that's it. Essentially, it can be part of the armory, can't it? All this could be hidden from view. Do you tell your clients to ignore that or to take it seriously?
Well, I mean, what they normally have is not for publication on the top, which you're familiar with. And I get asked by puzzled American colleagues, American lawyers, how any letter could have that effect. What is this thing that is a lawyer's letter threatening legal proceedings against a journalist that is not for publication? It doesn't have any particular status as such. It can get you into trouble later on with the court if you publish it and you were asked not to. But as Rupert said in his introduction, the problem at that point, whether it's a letter in that form or some other form, which is an explicit threat and raises costs and the prospect of proceedings, is can you afford to emotionally, money-wise, in all sorts of ways, go on against what's being complained about, or do you just need to take a pragmatic position at that point and get rid of it all? Just get rid of it all by whatever it is, taking the article down, not putting that bit in the article, not mentioning that person. And so often, you ask me what I advise the client. I advise the client, if you've got limitless funds, fight it because you're in the right, if that's the case. You've got the evidence, you've got the law on your side, you've got the public interest on your side. Be brave like Carol and do it if you've got the money. If you haven't got the money, take a pragmatic decision about what you can do and what you can't do here. And you may have to trim and you may have to self-censor. And when that happens, that's the chilling effect that we don't see, as Carol is talking about. It happens across the board. It happens with investigative journalists, NGOs, local papers. It's the most worrying thing. It's the most unquantifiable thing. And it may be anecdotal, that we all know it happens and we see it and we deal with it. But it's got to be recognized by our politicians because it's the most serious threat to free speech in this country.
I once gave evidence to a House of Commons committee, and there was a representative of the local press there who said the moment they got a letter from a lawyer, they settled, and they just didn't have the budget to fight any case. So, once the word spread around the town, all you had to do was to write a letter to the paper, and they would settle. That was a disaster, but he was perfectly open about it. Now let's have some questions from the room. There's a hand there.
Yeah. Hi, my name is Maren Turner, and I'm the director of a US-based organization. And I just quickly wanted to share my own experience. You mentioned NGOs being subject to these kind of suits. We were once also threatened with someone for a defamation claim in the US, and our initial reaction was to fight it. And we went and we talked to lawyers. Not long later, we also decided to cave. And it had to do, we had called someone an oligarch in a public statement. The response came back very quickly with a letter from a lawyer. I'm not an oligarch. What is an oligarch?
Is that Mr. Blavatnik?
We had also made mention that he was close to Putin. He came back and said, I've only met Putin a handful of times. I'm not close to Putin. But ultimately, the advice we got from lawyers, we also have a charity status in the UK. So my concern was we were most exposed for a suit here. But when we spoke to the American lawyers, they were saying, look, you're going to win on summary judgment. And even if you get pro bono support, it's still going to be a lot to get there. They're then going to appeal it. It's then going to go back. And we were told as well, we're looking at 10 years. So even if we don't end up with a massive...
In which jurisdiction? Yeah. Or
this was in the US.
In the US. So it doesn't matter which state it was in, because there are some anti-SLAPP laws in certain states, aren't there?
I mean, the advice we got, we were one of several NGOs threatened, and it was we were all based in District of Columbia and DC. So presumably that's where the suit would have been filed, but we just didn't know. And then also having charity status in the UK, we thought they can come at us here as well when they find that out. And this person was already lawyered up. He was facing extradition to the US. So he had like a whole kind of arsenal of lawyers there. We caved, we were terrified. Because even though we thought we could secure pro bono support, we weren't sure for how long we would have the lawyers willing to work for free. And then 10 years, I mean, it was going to just drag the entire organization into this. And so
this is a paradigm. This is a paradigm example of the need for early disposal and also for cost protection for the party who's applying for the early disposal, which is what you would have been. So you can get a pro bono lawyer to do the application. You can knock the case out or try to knock the case out, and the law will protect you against an adverse costs order up to that point, provided it's a good faith attempt to get rid of the case and the judge says it's not, you know, it's not completely misconceived, there's a basis for it. That's what's of value, because then you don't have to cave. You can have a go at the early dismissal or stay of the procedure with your low cost pro bono lawyers, in the hope that that ends it. That's exactly what you need.
Do you want to come in on that?
I just want to actually just say, I should also say thank you to RPC and Keith Mattias and Tom Otter, who were here, who have but they've sponsored this event tonight, and for Gavin and Adrian, who were my counsel, who worked for on a conditional fee arrangement. And so that support of the lawyers was also part of why I was able to fight this. So sorry, I just wanted to say put that thank you in as well.
Very, very important. Yes, Jonathan. Yep. Sorry, there's Jonathan, then Peter.
I think it's unrealistic to look for procedural solutions to this problem because it would be unprincipled to shut down litigation that has some prospect of success. And there are no actions which are so difficult to assess whether you've got no prospect of success than defamation actions. What this means is that the only way of approaching this problem is to alter the substantive law of libel so as to create a much wider public interest defense. Now that would be tantamount to doing what the politicians don't want to do, which is to introduce something like a First Amendment right into the UK. It wouldn't be called that, but it would have much the same effect. We've got to be realistic enough to appreciate that until the politicians are prepared to accept a much wider public interest defense than the one that we've currently got, this problem is not going to go away. If we do have a wider public interest defense, it won't be a complete solution, but it will be a solution to quite a lot of cases, particularly if it was coupled with a statutory provision empowering the court to determine the public interest at a preliminary stage.
Sure. And Jonathan, as you were on the Supreme Court, I mean, the Supreme Court has wrestled in its own way in trying to arrive at a position where there is some protection for a public interest defense.
Time something gets to the Supreme Court, £1 million has already been expended on the way, so that what we decide is not actually a solution. It may be a small step towards one.
Peter.
I'm particularly fascinated about what we as little British people are especially good at, our country specialisms, the city, etc. Is it fair to say that we are specially good at slaps and that this is a thriving little industry? And is it unfair to murmur the gorgeous name Kingsley Napley? I love to say that because it's a lovely name. Is it fair to say that there exists in lawland, not so very far from here, a number of practitioners who say that they, just like PRs, are reputation managers. And what they mean is they'll slap somebody for you if you give them enough money. Is that a British specialism, and should we be proud? Should we be proud that it is so, that we're very best at slapping?
I think it's a point that met with applause, but unless you want to come in and
To the extent that's the case, we should be ashamed of it.
there's a question here at the front and a question at the back there.
Thank you very much. I'm Godfrey Cromwell. David is fighting this with his friends in the Commons. I'm fighting it with my friends in the Lords. That's how it's playing out. We're going through the economic crime bill at the moment, and just to the last speaker, I can't resist saying that in my speech on it, I said the economic crime is something we're a market leader in, and should we be proud of that or not? I think there is a strong coterie of law firms that will take on this work for a fee. My question is this. The problem with slaps is definitional, as I think we've covered. When is a slap not a slap? Yes, we do need some sort of way of defining it, the sort of criteria that you laid out earlier, but the key to it is the early settlement, because you can get a public interest defense, but if you spent $1 million, $2 million to get there, it hasn't really solved the problem. My point to you is, talking to senior former law lords, for example, is the issue that solving a case of this nature requires the judge. It isn't the lawyer who decides whether it's a slap or not. Ultimately, it's the judge. And it requires the judge to look into the mind of the person bringing the case and decide, are they doing this for harassment, or are they doing it because they're genuinely defending their reputation? Now, traditionally, our judiciary are very reluctant to try to look into the mind of the person bringing the case. So to my mind, the key thing here is the definitional one. And the previous behaviors, the nature of the case, all of the steps you laid out earlier, and I won't repeat them all, that's the key to getting closer to a definition, but it's going to be a continuum. There'll be cases where people are genuinely defending their reputation. And if they want to spend £10 million doing it, that's up to them. There will be particularly egregious cases at the other end of the scale, which the judge will be able to throw out. And then there's going to be this grey land in between where sometimes you'll get it, sometimes you won't.
I mean, do you want to talk about whether judges are reluctant to look at the intention of an action?
No, they're not reluctant to. In fact, most of the abuse law that we have requires them to look at intention and purpose, and that's an issue that works its way into most definitions of slaps. I'm very reluctant to see that become part of an anti-SLAPP law, because I think if you get down into the weeds of the claimant's subjective intentions, their subjective purpose, it's almost impossible to characterize it as a slap, because they'll give detailed evidence in a witness statement about why they're doing what they're doing, and unless you can disprove that, you're not going to get anywhere. So it has to be, the test has to be as objective as possible, and that's why I said personally I think the answer is for the judge to do a broad balancing exercise between the societal value of the speech and the consequences of allowing the case to go ahead for our democracy on the one hand, and whether the claimant really needs to resolve the issue about their reputation or the harm that they're complaining about through this lengthy, costly and damaging process, or whether they can just answer the allegation in the court of public opinion or just live with it. You know, that sort of broad-based evaluation is actually not that difficult to do for any free speech public lawyer, judge. You can spot a deserving, I want to defend my reputation case when you see one. You can spot one that isn't and that's concerning, but we just don't have the vehicle for judges to do that. We don't have the mechanism.
Can I ask a question? Why should a reputation only be afforded to a rich person? That's how it works in this country. A poor, like if people are being endlessly libeled on Twitter, everywhere else, and so live with it, suck it up. That's the rule. Whereas it's only if you've got vast amounts of money at your disposal that you can go, my reputation is my honour, and take a case and go after that person. So I just don't. There's just a pure element of fairness, which is, it seems to me, at fault here.
We've got time, I think, for 2 more questions, and I think that's Andy.
Marion.
Come over there.
Marion.
Well, first of all, Andrew, because he caught my eye first.
I acted for Belton and for Burgess, and I therefore have a perspective on this. I am much more pessimistic than Gavin about the practicality of early applications in cases where the allegations are serious and the facts are complex. Seems to me that Jonathan is right to say that the answer must lie with the substantive law. But I would add to what he said, it's not merely the politicians. I think the judges have had opportunities and not taken them. And also, just take Section 12 of the Human Rights Act, which was lauded for that expression, will have particular regard to freedom of expression. And what did the judges do? They said that the right to reputation, the right to free expression was exactly the same, and they all start equal. So that was the first missed opportunity in it. If you read the debates, it was not what Section 12 was intended to do. It was intended to give a bit of real oomph to Article 10. So they start off equal, that's the first thing. The second thing is that it all depends on what is in the public interest. The next misstep, in my view, was that slight train spotters approach in Reynolds, that you have to do this and you have to do that. Unless you get 8.5 out of 10, you're probably going to lose. And trying to predict how you were going to end up on that exam paper was remarkably difficult. Now we're with Section 4, which has, I think the test is not bad, but the real question is, what is a reasonable belief in the public interest? Where do you take an anonymous source as a very simple, short example? Does the anonymous source weigh less than a named source? How is the journalist to weigh it? And at the moment, the microscope the judge puts on these problems is very intense. I'm not convinced that the First Amendment is quite the answer, but I'm certainly convinced that the common law should develop in a far more Article 10 friendly way than it is at the moment. I'm not sure that's a question, I'm afraid.
It's a magnificent statement. Because time is short, we want to get at the drink. I'll take it as a statement rather than a question. And yes.
Hi, I'm Marion Jones from the Bureau of Investigative Journalism. We're being slapped by Jusan Technologies, which may or may not, I'm not making any judgment on this, have looted billions from Kazakhstan and landed it through London. That's to be determined. We are incredibly grateful for the work that David Davis, Liam Byrne, all these MPs and Lords are doing to try and get a prompt law through. I don't want to wait years for a First Amendment. I'd love to see it. But from our point of view, the stress that this causes, the amount of time it takes up in a relatively small organization, instead of chasing wrongdoing, tracking down people who have done terrible things, trying to do stuff about the devastation of the Amazon, all these things that we work on, we are completely consumed at a senior level with dealing with a court case which is designed to do exactly that. And it sent that message to us, to Open Democracy over there, to the Telegraph. All of us are being sued on this. It is a warning to everyone else out there to say, do not go after difficult subjects. Do not go and try and track down these wrongdoers. So I would rather that David Davis and Liam Byrne and the rest of them manage to get something through now, which saves us. And let's, put off the debate about the First Amendment till another day.
Well, that's a very powerful way of injecting some urgency into the discussion tonight. But thank you, Marion. Do you want to just end with any concluding remarks before we go and get to the drink? Yes.
I mean, I think, sorry, that was very powerfully put by Marion. And I think if you haven't seen it, the Netflix documentary about Jimmy Savile, which Marion's in, is also, it's a really good explanation for people who don't, but for anybody really, about the way that, an abuser at that scale wasn't brought to justice before he died. And that had a lot to do with the application of SLAPP defamation lawsuits, wasn't it, Marion? And I find it's like that sort of realizing the stories. I think as journalists, as editors, we know how many stories do not see the light of day. And that is one of the most terrifying things, I think, really.
I should also say we're lucky enough to be represented by Gavin.
Gavin,
It's all getting very intimate here. So, I mean, Jonathan's point, I agree with it. It's the point I was making earlier on, which is you're trying to build a procedural protection on a substantive law that isn't sufficiently pro freedom of speech. It should be, but in America they have both. They have substantive law that's protective of freedom of speech, and they have the anti-SLAPP mechanism. And my question is, why shouldn't we have both here? I appreciate it'll take longer to get the first one, but ultimately, why shouldn't we have both here?